Hello there, Civil Barrister Rob Latton. How are you doing today?
Very well, thank you, Stephen. How are you?
I am coping. I think more than coping. I'm doing okay. And just before I came online, I was just trying to figure out A, what day it is, and B, what day of the lockdown it is. Perhaps you could give us some initial guidance on that topic before we move on.
Well, those are very relevant questions, Stephen. It's Tuesday, and we are in day 6 of the lockdown.
Day 6. And I was just having a little argument with a friend, so to speak, about when our Prime Minister told us it would be about a month. Is that, and I'm asking for your lawyer to come out here, your inner lawyer, and your outer lawyer actually, is that 28 days or is it a calendar month from the announcement?
I think she said 4 weeks.
4 weeks.
So the initial term of lockdown. So presumably it would be to last until, I can't remember the date it was imposed. The days are running together. But it would last until midnight on Wednesday of the appropriate week, unless on the off chance it was extended further.
Yes, well, and I suppose an extension is a very real possibility, isn't it? But I think everyone would be thinking we will collectively cross that bridge if it's built. But anyway, Rob, we had agreed that we would spend a little bit of time talking about a legal concept that may have some bearing on the C-19 pandemic. I'm just encouraging people to call it C-19. You can do that too, regard that as optional. And the concept is one of frustration, not the feeling you get with the TV set doesn't work or being locked in, and if you're a single person just having to stay home and essentially just ruminate for 28 to 30 days or whatever it happens to be. But anyway, frustration is a common law concept. It might be applicable. Could you kind of explain what that is?
Frustration is a means whereby a contract is automatically discharged. In other words, where if a contract is deemed to be frustrated or meets the legal test for frustration, neither party is obliged to continue performing it. And so in these times, you and I have probably had quite a few inquiries from clients who are whose contractual obligations or contractual relationships have been upset by the lockdown or by the pandemic, and are looking at their options in relation to it. One of the most common sort of inquiries that I've been getting is about people who have been wondering about what effect this pandemic, this lockdown is going to have on their obligations under their leases, either as a landlord or as a tenant. I think that for the purpose of, or for the sake of today's discussion, we should avoid leases because, I mean, we could have a whole other interview talking about that specific provision, and there are some quite specific statutory provisions that apply to leases. But in terms of frustration of contract generally, frustration happens when you have a situation where something that's unexpected in terms of the subject matter of the contract, where something unexpected occurs, where that thing is something that is beyond the control of the parties, and where that thing or event makes performance of the contract impossible, or where it makes the relevant contractual obligations radically different from those contemplated by the parties at the time they entered into their contract. So that's the doctrine of frustration. As you can see, or as is obvious from just having heard what frustration is, obviously an event like the the C-19 pandemic, the government lockdown, is something that very obviously raises the issue of frustration in a lot of contracts.
Well, that's interesting. And so, how do you think it would apply generally in the pandemic, and possibly looking at a few examples? And just before you embark on that, one kind of question in my mind is, and again, this kind of echoes an idea that arose in our first discussion about business interruption. On the one hand, we have the fact of the pandemic, which is a factual situation. Pandemic being, the global spread of a disease, not necessarily to any particular extent. On the one hand, the government lockdown on the other. So in a hypothetical, well, in the situation that we presently have, where there's a lockdown for 4 weeks,
yeah,
and also the fact of the pandemic, what kind of impact could that have on contractual obligations?
Well, I think so. If you look at the three elements of frustration, clearly we are in a circumstance where there has been a radical change in circumstances. So the first test of whether a contract's frustrated has probably been met. And there are all sorts of contracts that are potentially affected by this shutdown. Delivery contracts, for example. If you have entered into a contract to purchase a house and settlement is meant to happen on a particular day and time is of the essence, potentially that's something where frustration applies.
Okay.
Anything where time is of the essence really is potentially affected by this pandemic and could be frustrated. And obviously it could go wider than that as well. Essentially, any contract where performance has become impossible, perhaps impracticable, due to the lockdown or perhaps the pandemic, is a contract that could be ended due to its objects being frustrated.
Yeah, that's interesting. So it seems to me that there might be kind of 3 broad categories, and possibly more, but I just jotted some notes while you're speaking. One where time is of the essence, and perhaps another way of putting that is that there's a specific obligation that accrues during these 4 weeks where something must happen on a date and it literally cannot happen by reason of the pandemic. A situation possibly more broadly where, say, you have the delivery of 1 million widgets a day, and so not doing that for 4 weeks is kind of a material change. Not that that's the test, but clearly that kind of makes a radical difference to things.
Well, that's something that might make that might radically change the obligations that were in the parties' minds at the time they were contracting. So, for example, you might need to get 1 million widgets a day from a factory in a place that's subject to a lockdown. And this may be more relevant going forward. And obviously that factory is in lockdown and can't provide those widgets. Normally the contract wouldn't allow you to go away and find an alternative source of supply for those widgets. But if they're not able to be supplied, you might be able to argue that your contract's been frustrated and you're free to get them from another source so that you can continue your own operation or something of that nature. So yes, that I agree with that second category you've posited.
Yeah, right. And the third category, just pushing it way out the other end, I have a contract of insurance with an insurer, and actually looking at it from the insurer's point of view, if they've agreed to insure me for a year, other things equal, the fact of the pandemic is not something that makes a relevant difference. You could say there's a substantially increased possibility of me falling ill, which perhaps draws another considerations, but not one where you could argue frustration, I suppose. And also, I have a retainer to provide litigation services for a litigation file where it's contemplated that may go over 1 or 2 years, I dare say, for a complex matter. And it wouldn't really be open to me to say that anything had been radically changed. Something arising out of your response to my second category is the consequences of frustration. Just remind me, is it that if I declare correctly the contract is frustrated, all bets are off? Is that how it works?
That's it, yeah. So frustration, you can't say that a contract's been frustrated for a month or something like that. If the doctrine of frustration applies, that is the end of the contract. Now, quite often contracts will have particular terms in them that will deal with temporary interruptions to performance, and the most normal one would be a force majeure clause in a contract. Mm-hmm. And that will often provide for suspension of performance for a particular time. Frustration is something different. Frustration is something that is so radical, it means that the contract is unable to be performed forever, or that it's such a radical change in circumstance to what the parties contemplated at the time that it wouldn't be, that the contract should be treated as being at an end. So it is permanent. If a contract's frustrated, that's it. Mm-hmm. That's the end of it. And it's a real balancing exercise that the courts have to look at to see whether a contract has been frustrated. One of the important factors will be, what's the term of the contract? If you've got a 10 or a 15-year term for your particular contract, and the lockdown or the C-19 pandemic's going to affect it for 2 or 3 months, that may well not be enough to mean that your contract's frustrated. And in fact, there was a case in Hong Kong during the SARS epidemic that dealt with that very subject, where a contract, somebody tried to say that their contract was frustrated because they were unable to access a particular premise. The court there said, well, it was only a 10-day interruption in the course of a 2-year contract. That's not enough to regard it as frustrated. On the other hand, if it's a 6-month interruption or something like that, that's obviously a lot more significant. So it depends very much on the context of the contract and what the parties had in mind at the time they were contracting.
I'll just mention there before I forget, Rob, that I'll grab the details of that case for you, and I will post that material with this video so that the litigators in this audience can check that out. Because that case does sound quite on point, doesn't it? Reminding myself that C-19 is a kind of SARS virus.
Well, it is on point because it concerns a similar event, but what you have to remember about these sorts of cases is that they are very specific to their facts. And in that case, you had a 10-day interruption to a tenancy. The tenancy was meant to be for 2 years, and the courts held, well, a 10-day interruption in the course of a tenancy that's meant to last 2 years or, over 700 days is really insignificant.
It's very interesting.
And not enough to frustrate it.
Right.
Sorry?
Yeah, no, that is very interesting because there's a bit of discussion around the traps about frustration and leases, and certainly a question is ripening in my mind about that for our third session, but I'll keep it for that. Just while you were chatting, Rob, I was just reminding myself about the New Zealand Frustrated Contract Act 1944, not something that I've ever really
yes, well, that's now been replaced by the Contract and Commercial Law Act.
It's in that omnibus legislation, isn't it?
Yes. So
And
that there are specific statutory provisions that talk about the impact of frustration. The Act does not affect the common law test of whether a contract has been frustrated or not. That is still something that's decided by the courts using those three factors that I mentioned before. But yes, the Act does impact on certain the performance or the obligations of the parties post-contract. For example, it provides that if there's a provision in a contract that's been frustrated, that can fairly be severed from the contract, and it might be something like, for example, a restraint of trade clause. Frustration of the underlying contract won't stop a party being able to enforce that restraint of trade if the circumstances are appropriate. Certain contracts aren't affected by the provisions of the Contract and Commercial Law Act. So carriage of goods by sea or charter parties aren't affected by the Contract and Commercial Law Act. Contracts of insurance aren't, so different policy considerations apply to those sorts of contracts. And and there are a number of other provisions that are relevant to it, but they generally speaking deal with the consequences of frustration rather than determining whether frustration has occurred.
Yes, and for the more law nerd members of the audience, the reference there was to the Frustrated Contracts Act 1944, which Rob correctly pointed out has now been subsumed into the more recent omnibus legislation, Contract and Commercial Law Act 2017. And I was just reminding myself, i.e. learning, where that is in the new legislation. And I see it is from
sections 60 to 69.
There you go. 60 to 69, carrying forward the provisions of the former act. So at common law, so to speak, a contract was frustrated and then all bets were off from that point. And the general effect of the legislation isn't it, to take a more attenuated approach so that the court, if it comes to be adjudicated, can make appropriate orders to adjust for the circumstances, including with the example that you gave, a restraint of trade. Would you agree with that assessment?
Well, I think, yes, it does allow the courts to continue to apply some provisions that they think were clearly intended to apply even if the contract ended, which might not necessarily have been the case under the common law. They may allow, or the courts may allow some parties to whom money was paid or who to whom it was payable to retain or recover some of the money if they think it was fair, and various things of that nature. So you're right, it does allow, the court has more power to vary the remedy, I guess you would say, in terms of a frustrated contract than was available under just the common law.
Yeah, and so for anyone looking at the situation, they would be examining that part of the legislation to fully understand how, if push came to shove, a court would be making probably what amounts to adjustments of the parties' rights and responsibilities in light of the fact that the contract has now come to an end.
Say one of the parties to the frustrated contract, just because of their position, has somehow managed to gain a considerable benefit from the contract before it's frustrated. The court may order that they have to, return that benefit or part of that benefit to the other party, or something like that. So there's the legislation allows the courts to undertake a type of balancing exercise if that's appropriate in the circumstances.
Yeah, I've certainly had a few very general queries that have come in where people are kind of moving towards a decision about this issue. Are you aware of anything, I mean, subject to confidentiality and everything, that's a little more, just in a very general way, a little more concrete? Because
Yes, there's so one of the examples that I've seen is a take or pay contract for the provision of stored gas, liquefied gas, and that provided that a party would take a certain number of canisters of gas every week, come what may.
Right.
So, and got a reduced price as a result of that.
Right.
Now, the party that was to take the gas can no longer use it because they're locked down, their business is shut down, they have no use for it. But the contract, under the strict wording of the contract, they are obliged to take it. So you have a situation there where one party says, well, you're contractually obliged to take as many of these canisters of gas per week as the contract says you're obliged to take, come what may, whether you use them or not. And the other party's saying, well, that's not fair because I no longer have a business to operate where I was using 6 of these things previously a week, or 6 to 8 of these things previously a week, and would take delivery of a minimum of 7 and up to 10. Now I'm using none. And it's not fair that you say, well, you've got to take delivery of 7 a week or pay for 7 a week. That's the sort of obligation. Now, often in a lot of those types of contracts, a take or pay contract, which would be normal in, say, something like the electricity or energy markets, there will be a force majeure clause,
right,
which would allow you to suspend operation of the contract in circumstances like, potentially in circumstances like we're facing at present. This particular contract doesn't have a force majeure clause in it. And so one party is looking at whether they can get out of it because that's obviously causing them to bleed a substantial expense. And the other party's quite interested in making sure that the contract continues to stand up and continues to be honoured. Yeah, common sense would dictate that there should be a middle ground there, but that may not necessarily be the case, and frustration will be one of the things that's actively being considered, particularly by the person who's who's obliged to take the supply.
It certainly sounds to be a relevant concept in that scenario, and we're looking at, aren't we, not a situation where the contractual obligations are impossible to perform, but rather there's been the radical change to the purpose for entering the contract, isn't it? That's a radical change.
That's right. In that particular case, you would say that the relevant obligations are radically different from those contemplated by the parties at the time of contracting. Something's happened which is unexpected, beyond their control, the fault of neither. One person would say, well, the contractual obligations now are something that was never in contemplation at the time we entered into this contract. It's an interesting decision about whether that's correct or not. I mean, it's an interesting question.
Yeah, I wouldn't like to hazard a guess at this point. Look,
it's very fact specific. So you'll be looking at things like anything you can find to help you ascertain what the parties were discussing when they were negotiating this contract. Those types of things are going to be very relevant. Evidence about what's normal in the industry, normal industry practice, those types of things are also going to be very relevant. So,
right.
but it's, there's a large amount of money involved in this contract for somebody. So,
just an idea that's running through my mind as we chat is, and I'm not at all committed to this, is whether the government declaration that there be a lockdown, which is kind of legislative in nature, and therefore you say legislation, whether the passage of legislation can be regarded as an unforeseen event. Just
yes, it absolutely can.
Oh, really? Okay.
Yes. So change in law is one of the things that can cause frustration of a contract. I mean, you might have a contract to, for example, provide, saddles to the horse racing industry or something like that. And if the government turned around and made horse racing illegal, then that contract would certainly have been frustrated.
Oh, well, that's interesting. Yeah, you've taught me something there. And certainly there's a stronger case for that thinking where in this highly unusual situation, the legislation is, you shall not trade. I mean, you can't think of something more radical than that.
That's right. That's right. I mean, you could argue that having to shut down because of infectious disease or having your trade interrupted because of infectious disease is something that in some circumstances parties should have had in mind when they entered into a contract.
Yeah, that's up for grabs, isn't it?
It's more difficult, I'd suggest, to argue that parties should have had in mind that the government would mandate that business must stop for a prescribed or perhaps a non-prescribed period of time.
Well, initially prescribed, and I think that's where it starts getting quite dynamic, doesn't it? Because one scenario, which is quite likely, is that we have the pandemic, something declared by an international organization, and New Zealand kind of submits to that classification, and a 4-week fiat period. So a global radical change factually to some extent, a mandated shutdown for 4 weeks, and a subsisting pandemic that has an effect to some extent, maybe a large extent, maybe no extent,
that's right.
and everything in between. So I think that underscores how it will be highly fact specific, right?
That's exactly right.
Yeah. Okay. And I'm so tempted to get into leases, which is juicy. I've been exercising a lot of self-restraint during this discussion. Unfortunately, I don't actually have a timer, Rob, and I'm conscious that we both have the free package for Zoom, and I don't know if you know this, but there's actually a 40-minute limit, and unless we wrap up soon,
I have been prattling on quite a lot. I think
we might face a heartbreaking introduction unless we, stoppage, unless we start wrapping up.
I think we should. I think we need to have another whole session on the issue of leases, because there's a number of other considerations that have to be looked at with leases. Most leases will have terms, specific terms that will impact on your ability to get some relief from the obligations of the lease. There's legislation like the Property Law Act that applies. We could quite happily talk about that for a long time.
Oh, look at us getting into it. Oh, I'm so tempted to say something there, but I won't. Rob, if folks feel like getting hold of you, what should they do?
I think we'll put my contact details and your contact details at the end of this video.
Great. Okay. And like I said, just fling me the details for that HK case. You did emphasize that it's fact specific quite rightly, and certainly there's no rule of law that, a 10-day tenure does not permit you to plead frustration, and likewise there's no rule of law about 4 weeks or anything else. Is interesting to see HK, of course, is a common law jurisdiction that has the common law reasonably similar to our own, applies the law in a similar way. And of course, we are in a SARS outbreak of sorts, and that was a SARS outbreak, albeit not as bad, although obviously mainland China and surrounding areas were more badly affected back in 2002. Okay, Rob, well, thank you so much for your time. I'm going to sign off, and I'll be calling you around this time tomorrow if you're free to have a bit of a chat about leases, mate.
Excellent. I'm
Okay.
excited already.
Okay, until then, bye.
Thanks. Bye.